Good morning, everyone. This is Steve Sims. I am a corporate partner at Smith Amundsen. I'm glad you could log on and join us today. We're going to get started soon to allow everyone a chance to log on. All attendees are muted, but if you have any questions, please send them through the Q&A function. And we'll try to answer those either during the webcast, if it catches my eye, or at the end of the webcast. We're going to allocate hopefully 15 minutes or so for Q&A. I'd like this to be as interactive as possible. And we will send out the slides to everyone in the next day or two. Be sure to check your spam folder if you don't see them. Turn the slide, please. So a little bit of background on me. As I said, I'm a partner at Smith Amundsen. I've been doing merger and acquisition transactions since 1989, buying companies, selling companies, other change in control transactions. I have done this in-house as general counsel of a publicly traded manufacturing company and as outside counsel, most recently at Smith Amundsen. The industries that I've dealt with in my career are numerous, but just to mention a few: containers and packaging, manufacturing and industrial companies, including distribution companies, metal services, fabrication, software, and web retailing, to mention a few. The transaction size varies. I've done small, medium, and large transactions, anywhere from 50,000 up to 275 million. Turn the slide, please. Now, I wanted to just mention the presentation focuses on the sale of a solvent, privately owned business. This is not a presentation for the sale of a distressed company under the bankruptcy code or through an assignment for the benefit of creditors, an ABC. It's also not designed for the sale of a public company. The first and one of the most important things is to assemble a team of key professionals if you're thinking about selling your business. It's very much a team sport. Experience in M&A transactions is critical, and there are certain positions on the team that I think are especially important. Your first decision is going to be, it's a little bit, I would analogize it to the sale of your home. Are you going to attempt to sell your home by owner, or are you going to use an experienced broker? Business sales, at least operating businesses, are very similar. There is an industry, there are deal intermediaries. You've probably met or talked to some during your career. There are investment bankers, there are business brokers. And I have no affiliation with any of them, and I don't benefit from the use of their services, but I do think, in my experience over the last 30 plus years, they do have expertise in marketing and selling. They have expertise in creating marketing materials for your business. So I don't think you should skimp on marketing. So when you're thinking about selling your business, I always say you only get one chance to do it right. So make sure that you've done a professional marketing job. To go back to the house analogy, you want to make sure you have really good pictures of your home. Well, when you're selling your business, you want to make sure you have a really good snapshot of your business. It's professional, it's concise, it gets to the point, and intermediaries can help you do that. Now, there is a fee, associated with their services, but I would say more often than not, they pay for themselves, because you will probably get better value for your business. There's no guarantees, but in my experience, that's often the case. The other reason to consider using an intermediary is to allow you, the business owner or the management team, to focus on running and optimizing the business, because that's important. Because if there are hiccups during the sale process, that's going to hurt the sale process. The buyer might lose interest. And it's hard to do, it's trying to manage the process yourself can be complex and overwhelming, quite frankly. It's like having two full-time jobs at the same time, because the M&A sale process tends to suck you in, and it doesn't leave time to run the business. So you have to keep your eye on the ball, while you're engaging the process. The other point I would leave you with on deal intermediaries, bankers, brokers, if you use a registered broker dealer, it does afford some additional deal protection, especially in equity sales or equity transactions. So using a registered broker dealer can provide an additional level of protection that your deal will be maintained and not unwound somehow. Turn this slide, please. Other critical positions, and I can't say enough about tax structure advisors, a qualified CPA or a JD, and I think we have some on the phone today, are critical. And you want to do this early. Far too many folks wait until late in the process to determine what structure will yield the maximum after-tax proceeds to the seller. And when you're selling your business, that's clearly a paramount goal. You may have other goals, but that's important. We need to consider whether we need to reorganize or recapitalize the business before a sale. For example, you may have to simplify a convoluted company, family structure or capital structure to make your business easier to understand and more marketable. And I have seen, and I have done this in practice, and that's something to consider in advance. If you have one company, one business, and it's all pretty straightforward, you don't have to worry about that. But know that when we're talking about deal structures, sellers often prefer stock sales due to capital gains treatment. Buyers often prefer asset purchases as a shield from unwanted liabilities. So there can be a tension. There are some techniques to bridge the gap, such as a sale of personal goodwill if it's applicable to your business and to your ownership group. And again, it goes back to tax structure advisors. Make sure you have one on the team. Talk to them before you even market the business so you know what kind of transaction you want to do and what you want to present to the market. And thirdly, the M&A lawyer, that's me or someone like me, is a deal quarterback. They know the market norms, kind of the bid and ask for key deal terms. And we've learned this, in my case, for over 30 years, and we follow. A good M&A lawyer keeps up on the trends. They follow the ABA market trend study for private transactions. They know what key provisions should look like in terms of things. I won't get into the too granular detail, but things like caps on indemnification obligations, deductibles, things of that nature, survival periods for reps and warranties. An M&A lawyer also should be a creative problem solver, a person who knows how to work around the monkey wrenches that will inevitably be thrown out during a sale process. So those are your key team members, obviously in addition to the ownership team and the management team. Whoever's charged with selling the business is the most important position, but these other three, the intermediary, the tax structure advisor, the M&A lawyer, are also important. Now, what you want to do, the goal here is to maintain goodwill with the buyer. Oftentimes, you or some of the owners will still be working with the buyer post-closing. They could be consultant to the business, they could remain an employee for a period of time, or they could still be a shareholder. Oftentimes deals are structured where the key managers roll over some equity into the deal, and they end up owning a portion of the new company that's operating the business. So you do want to maintain goodwill. And this is another reason to use an investment banker or an M&A lawyer. Let them be the go-between. And if there has to be a hard message delivered, there's a tough negotiating point, let them deliver the message, and you can keep your goodwill. Turn the slide, please. You'll want to do some research on what's a realistic valuation or range of value for your business. Intermediaries, another reason I would consider an intermediary, they have good sense of what to expect. They monitor comparable transactions and EBITDA multiples for your industry. So they'll have a sense of what a business like yours may be worth to the market. There can be some public data available, but it's limited to public company filings and what they file with the SEC through EDGAR about acquisitions they've made. So that's a limited data set. You can also engage a valuation expert or an appraiser. Although remember, there's no substitute for a market check, right? So what would a willing buyer and a willing seller do in a real world transaction? So if you know you want to sell your business, you should market the business and solicit bids or indications of interest. You can do this on a targeted approach. You could say, we just want to approach, the the top 10 strategic buyers in our industry, or we want to go to private equity, or we want to approve each person who's approached. Or you can use an auction approach, where you can throw it out to anybody and everybody who wants to bid. And again, the broker, the bank, investment banker can help you run that process. Turn the slide, please. Another critical thing, we need to build consensus within our ownership group. So if we're not all on the same page, dissension in the ranks is deadly. And you have to ask yourself the who, what, when, where, and why is a good way to think about it conceptually. Okay, so number one, who is exiting the business? Are all owners going to exit the business? Will there be a portion of the ownership group that would roll over equity into the new company? And also, who is going to stick around? Oftentimes, buyers want transition assistance. So which owners, which key managers will stay post-sale and receive an employment, a consulting arrangement, or something to document that relationship? Turn the slide, please. Then we have to ask ourselves the next W, right? What are we selling? So in an asset transaction, for example, you're going to have to itemize the assets of the business that are included in the sale and the assets of the business that are excluded in the sale. You do a similar analysis on liabilities. What liabilities is the buyer going to assume? That includes obligations under contracts, and what liabilities should be excluded from the deal. If you own or lease the real estate you operate on, your facilities, is that included or excluded? If the real estate that you own is excluded, what will the lease terms be going forward? And that usually includes, a negotiation of market rents and terms that may be different than the related party lease that was in existence before the sale between affiliates. You should also consider the allocation of tax benefits and liabilities, including new items that came through the CARES Act related, legislation. So, for example, there are some employer tax deferrals and employee retention tax credits and NOL, net operating loss deductions that are available now, but they may relate to pre-closing periods, and the seller may want to retain some of those items. The next thing to think about is when are we selling? So, a timeline. You need to have, call it a Gantt chart, call it a chronological timeline of the plan for the sale process. So, and more importantly, what do we need to do in advance to prepare the business for the sale? So, preparation is key. What is the optimum time to sell the business? So you have to look at your trend, right? It's easier to sell on momentum, on growth and earnings. We all know last year was tough because of COVID. It may still be tough for your business. But buyers like momentum. They like earnings growth, and they'll pay for it through an EBITDA multiple. So timing is often critical for a sale. How long will the process take? In my experience, deals almost always take longer than the parties expect or want. So from conception, the time you decide we want to sell our business, to execution, I mean a closing of a transaction, could easily be 6 to 12 months or longer, depending on your circumstances in your industry. I like to say that, always preparing for sale, may be the best practice to shorten the cycle. An unsolicited offer could be made at any time for your business, but if you're prepared for it, that cycle time will be shorter. New slide, please. And then the where are we selling doesn't fit grammatically exactly, but really who are we selling to? You've got your strategic buyers. These are competitors or people in your industry or related industries. There are financial buyers, private equity firms. We've heard from investment bankers and others that the PE firms are counteracting some of the COVID effects. So the COVID, hurt business results, but the PE firms have a lot of dry powder. They have a lot of money they want to invest. which has helped prop up multiples a little bit. So that's a good bit of feedback from the market. And you can also, as I mentioned before, you can do an auction. You can literally set up an auction process and invite all bidders or anyone who has an interest in your business. And then finally, you know, we have to ask ourselves, why are we selling? Because the buyers want to know. They want to know the backstory. They're looking for red flags, right? Are you selling your business because there's a problem and you just don't want to deal with it anymore? Or is the business being sold because the owners, operators want to retire, they've run out of gas, or does the business need more capital resources for growth and needs to recapitalize the business? Things like retirement and, you know, capital resources are good reasons to sell and will be viewed favorably by buyers. If you're selling because of hardships or problems, that's not as compelling of a story. But at the end of the day, remember, you need to have one story and one voice about your sale process and decide who will be the spokesperson. Or if you have multiple spokespeople, make sure they're saying the same things. A deal intermediary like a bank or broker might be the right choice. But remember, mixed messaging kills deals. If they're hearing two different things or three different things from different people on your team, that's not good for the process. Turn the slide, please. So I talked about preparation. So we want to get your house in order before the sale process commences. And this is not a comprehensive list, but these are just things that often come up and you should think about. You know, is your company in good standing? Have you filed all the reports and paid the franchise taxes and fees in the state of your organization and states where you may be qualified as a foreign company? Are you qualified in each jurisdiction where it's legally required? That's usually an analysis your lawyer would do based on, you know, where are your sales, where do you take orders for your goods or services, things of that nature. This is a different analysis, but this gets back to the JD or the CPA with the tax background. Are you paying taxes everywhere you have the requisite nexus? That can be a potential tripwire if you're not, and there's some steps you can take to verify that, which I'll get to in a moment. If you operate under assumed names, have you filed them? Have you kept them current? Have you renewed them? These are usually trade names, you know, names that you use in the industry, but it's not the same as your formal company name. If you're a corporation, have you elected directors and officers every year and documented this in your company record books? Because the buyers will ask, their attorneys will want to see that. Likewise, have all important decisions, things like borrowing money, mergers and acquisitions, other fundamental changes that you've made to the business, have those been documented by the shareholders or the members, the directors, the managers? Do you have that documentation in your company record book? Because that answers a lot of questions. And if you keep good records, it's a bonus during a sale process. Next slide, please. You want to take a look at your ownership agreements, and this ties back to the building consensus in your ownership team. Do you have ownership agreements in place? Do they include things like tag-along rights? So a tag-along right, or sometimes called a parallel exit right, means that a minority owner of the business has the right to exit on the same terms as the majority owners of the business. A drag-along right is a corollary right where the majority can literally drag along the minority. So if the majority wants to sell the business, all or part of the business, they can require the minority owners to sell on the same terms. And ROFRs, right of first offer or right of first refusal, gives one owner the right to accept an offer that another owner may receive for the business. But the bottom line on these are restrictions. The way I look at it, they're restrictions on transfers, they're restrictions on the ability or the manner in which you can sell a business. And so if you haven't built the consensus, if you don't have everybody on board, this can be a problem. So this is something you want to look at or have your attorney look at early in the process, or maybe you even want to revise those agreements. The second point I wanted to make here is, do you have, when we're getting our, house in order, so to speak, do we have written confidentiality, invention assignment, non-solicitation, and non-compete agreements in place with key employees? And this is an area of inquiry that all buyers will make, their attorneys will make. They want to make sure that the business is protected from, the quote-unquote rogue employee, if you will. Likewise, you should look at your material customer and vendor agreements. Are they in writing? Are the terms advantageous or disadvantageous? Are the contracts near expiration or have they expired, need to be renewed? The time to negotiate and renegotiate may well be in advance of any sale process. It's if you remember what I said, it's difficult to sell a business and run a business at the same time. What makes it even more difficult is if you're trying to run and sell the business and renegotiate your contracts all at the same time. So I would encourage you to take a hard look at your contracts well in advance of the process. See what needs to be fixed, see what needs to be addressed, and then it's easier to hand off those contracts to a buyer or their attorneys who are doing due diligence on your business. Next slide. So I like to think of, I just mentioned due diligence. So after the typical sale process is a bidder or an interested party signs a non-disclosure agreement. You look at the various bids, you try to pick the one you like the best with your advisor's advice, what looks like the best deal, all things considered. And then typically you'll enter into a letter of intent, preliminary agreement. It may include exclusivity, but after that, the buyer engages in due diligence. They start to look at all the things we talked about and more. So one of the things I like to encourage people to do if they're thinking about selling is to engage in some reverse due diligence in advance to be proactive and locate potential tripwires for your transaction. So one of the things you can do is you can get from an M&A lawyer or investment banker a typical due diligence request list. So we can provide you a list of what buyers typically want to see in advance, and you can start to build a virtual data room for speed and efficiency. So in the old days, we used to, I've been doing this for a while, we used to sit down in conference rooms and look at boxes of documents. Now it's all done virtually, ShareFile and other products designed for M&A transactions. So everything gets uploaded to a virtual data room. At some point when bidders have qualified or you've selected your transaction party, your counterparty, you give them the keys to the virtual data room and their advisors, their attorneys, their accountants, their bankers, whatever. And this is where all the repository of information for your business, everything from company records to contracts and so on and so forth. So you can start to build that in advance and have it ready to go. Some companies actually maintain this type of data room or this type of share file all the time. And buyers, will come in, they'll turn over every rock. They're looking for red flags, and they're going to take a hard look at these documents. So you can anticipate and resolve potential objections in advance. The other area, in addition to the reverse due diligence, these days buyers often want quality of earnings studies. So they engage an accounting firm to come in. This is typically after a letter of intent is signed, and they review your results, your earnings. They do a very deep dive into your financials to verify the quote unquote quality of your earnings, because that's usually the basis on which the business is valued through an EBITDA multiple oftentimes. But you could do this. You could engage such a quality of earnings study in advance. You could do your own and have it ready, or you could have your outside CPA accounting firm do a higher level of review of your financials, and maybe you could avoid a quality of earnings study. So if your financials are compiled this year, you could have the auditors do a reviewed set of financial statements. If they're currently reviewed, you could move to an audit standard. So the higher level of inquiry the accountants have engaged in reviewing your financials, the better the buyers like it. They have a higher confidence level. Turn the slide, please. To continue along in our reverse due diligence, if you will, You can also look at one of the big items on financials are GAAP, or deviations from generally accepted accounting principles. You can have your accountants prepare, or your internal staff, a GAAP accounting deviation schedule in advance and explain the financial impact on the business if you were to comply with GAAP. And you can have that ready to go, or as I said before, you can change your accounting standards and get them into shape before you commence the sale process. Another big one, especially if you own or rent real estate and it's in an industrial area, or even if it's not an industrial area, many buyers are going to want at least a phase one environmental assessment. If they're going to move in and operate at your physical location, if they're going to buy the property, they're definitely going to want a phase one. And oftentimes, if they're using debt, the mortgage lender would require it. And if the phase one indicates a potential issue, or they recommend a deeper study, you could move to a phase two. You could do samplings of the groundwater, that type of thing, and really create an environmental profile for the property. Obviously, this is a bigger issue in a brownfield area, a place that was heavily industrialized, but you never really know what the real estate was used for before you took over unless you engage in this type of study. You can also consider an employment law audit. There have been many changes, and I don't know, we might have a few employment HR people, employment attorneys on the phone today, but there's been a ton of changes since COVID hit with the requirements for employers. It's not a bad idea to have an employment attorney do an audit, make sure you're paying people properly, and the paid sick leave and so on and so forth is all copacetic, and you can have some assurance that a buyer's not going to find a problem or try to penalize you for it. I mentioned before, if you're going to keep ownership of the real estate and rent it to the buyer, you need to do a fair market real estate rent analysis. Many commercial real estate brokers can help you with that. And likewise, in terms of paying taxes in the right locales, you can consider a tax nexus study. This is something, again, that a tax accountant or lawyer would do for you if you're concerned about that. Next slide, please. The next thing I wanted to talk about is just cleaning out the closet. And it's a variation on, getting your house in order, but there are things that typically buyers don't want to deal with or don't want to assume. And so one of the things you can do is disentangle the owners from the business. So if the owners own important assets used in the business, maybe those need to be moved to the balance sheet of the business. If there are related party loans and transactions, can we unwind them? Can we pay them off? Because the less related party and affiliated transactions you have in place before you commence the sale process, the better off you'll be. You won't have to answer all the questions or exclude those transactions from the deal. It just makes life a little bit easier. You'll want to deal with any problem employees or contractors. Buyers don't want to inherit your problems. You'll want to resolve contingent liabilities. Maybe claims that have been made against the business, but it's not ripened into litigation, but you need to clean it up before you begin the sale process. Same thing with outstanding litigation. Most buyers won't take it, so you might as well try to settle the case or resolve it before you engage in a sale process, because oftentimes they're going to strip that out and leave it behind with you anyway, with the sellers, make you responsible for that. Have you had COVID-related, contract breaches, customers or suppliers who could not meet their obligations? And is there something we can do to resolve those breaches in advance? And of course, you should resolve any legal non-compliance issues, including some of the employment-related changes surrounding COVID. For example, the enhanced paid sick leave. Has your business complied with those requirements since they were enacted? Again, the employment law audit can help a lot with that, making those determinations. Next slide. All right. I know confidentiality is a big concern, and I also put attorney-client privilege in the same category, especially if you have pending litigation. So the first thing to note, and I don't have it on the slide, I apologize, but and I mentioned it before, all bidders and potentially interested buyers have to sign a non-disclosure agreement. A good one would include non-solicitation of your employees. So that gives you a high level of confidence. So the people that you let into the process and you share data with about your business, maybe through preliminary information about the business or the virtual data room, that needs to be protected by a non-disclosure agreement, and that gives you some confidence that you can speak with these people and share information, and it's not going to get out into the marketplace in a way that might harm the business. You know, it's the old adage, loose lips sink ships, and that's also true for internal folks, employees who talk to their friends at another company. So you want to make sure you've limited this information on a need-to-know basis inside your company, and that people aren't talking, you know, with people about your process that might, in a way, again, might harm the business. So you want to control the publicity and the quote, you know, the spin on the sale of the business. You want to be in charge of those communications. You don't want a word to slip out and have your competitors running around the marketplace telling everybody, oh, they threw in the towel, they're selling the business. So, you know, that should not really happen until there's been an announcement by the buyer and seller that you have a definitive agreement to sell the business or that you've closed the transaction. So that's why confidentiality is so important. So same thing with employee communications. Keep it to a small control group. As you move towards closing a transaction, you can start to bring in more employees, but make sure they've all signed a confidentiality agreement. You may have one in place. If you don't, you might want to consider them, or make sure they understand that they're not to talk about this outside, you know, the seller group until the transaction is done. Likewise, if you have a pending case, you don't want to share the attorney-client privilege information with the buyer or their advisors because you may spoil the privilege. So as I said before, oftentimes the buyer may say to you, well, we want you to retain responsibility for this case. In those instances, you should make sure that you maintain the privilege so the seller retains the related attorney-client privilege information, and that can be done in the agreement. Next slide, please. I want to talk a little bit about the marketing. So what do you say about your business when you go to market? Obviously, you want to tell a positive story, but my advice is don't overhype the business, the financial results of the business, or projections, especially projections. You should explain the effect that COVID-19 had on your business and any mitigation measures you've taken. You should have confidence in your numbers, and this goes back to the level of accounting review or the quality of earnings study that I talked about before. You should know that all acquisition agreements, at least by experienced buyers and attorneys, and that 90% of the time that's what you're dealing with, they're going to include representations, warranties, and indemnities from the sellers to the buyer, including the financial statements. So if you overpromise and underdeliver on the financials, you may be setting yourself up for an indemnification claim or a lawsuit down the road, and they do happen. People think, well, that never happens, but they happen. I can tell you from experience. That doesn't happen in every transaction. It probably doesn't happen in a majority of transactions, but occasionally you have a dissatisfied buyer who brings a claim or a lawsuit against the seller. So you have to be careful not to, like I said, overhype the business. Next slide, please. And I think I touched on this, but you know, you want to control the process in your timeline. So time is the enemy of deals. If the process gets bogged down or stops, the buyer may lose interest and move on to something else, especially financial buyers like private equity firms. They have lots of deals to look at. So you want to establish and maintain momentum throughout the process. And I think the way you do that is a combination of preparation, so the things we talked about before, and having a good deal team. So having the key players to help you move the process along, because a slow M&A process is often a troubled process, and it may blow up. Next slide, please. So there are some areas I wanted to talk about today that I think are potential deal killers, and there's been some some recent publicity about the hazards of some of these items. So, for example, you know, the cybersecurity incident, the hack, the breach of your data security, and a good example is the Colonial Pipeline hack. Their pipeline's been shut down for, I think, going on a week, and it's causing disruption throughout their markets and with their customers. If Colonial Pipeline was in the middle of a sale process, I guarantee you it would come to a dead halt. You'd be dead in the water. So you do want to address, you know, it's a growing threat today. So you want to consult with advisors about your cybersecurity, your data security, your privacy, compliance with privacy, and be as proactive as you can on that. You might even want to do an audit with a qualified privacy professional. Another area that's important to think about is the intellectual property, right? So a lot of times the most valuable asset of your business is your IP. Is ownership and the right, title, and interest in that IP contained in the business? Is it where it's supposed to be? So I've seen some horrible examples where, you know, maybe the founder of your business filed the trademark for your business, and maybe the trademark is very valuable in your business, but it never got transferred to the company. It was never properly recorded or transferred to the company. Then you sell the business, and if the buyer doesn't do a good job on due diligence, they find out, well, the business doesn't have the right to this trademark, to this trade name. Then they have to go back to the founder and say, hey, would you mind transferring that or selling it to us? And it could be very expensive for the buyer, and it could even create a claim or a litigation between the buyer and the seller. So make sure you've taken an inventory of your IP, that you have everything, you control, you have ownership of all of that within the business that you're selling or the company that you're selling. We touched on environmental. Environmental can often create a situation where if the potential environmental risk is too large and the seller doesn't want to be fully responsible for it to the buyer will walk away. So this is why I think, you know, doing the phase ones, the phase twos, if you haven't done them recently, is a good idea to make sure and verify whether you have a serious environmental problem or not before you launch into your sale process. Likewise, if you're familiar at all with the Foreign Corrupt Practices Act, and there's similar legislation in other countries, you know, a bribery or corruption scandal where someone in your company or in your universe, your affiliates, your associates may be doing something with domestic or foreign officials that they shouldn't be doing to generate business, that can cause huge problems, and there can be large damages and government investigations for FCPA violations or other anti-bribery and corruption statutes. It's not common in every business, but it's something to think about if you think it's an issue in your business, just to encounter these types of issues. Obviously, governmental regulation and legal compliance issues need to be addressed. I could just share a quick vignette, a story about a situation where we were attempting to sell an auto garage. You know, simple business, it was an automotive repair shop. They had, you know, let's say 8 bays in their garage, so they could put 8 cars or trucks up on lifts at a time to work on them. So it was a pretty, you know, sizable business. But at the 11th hour, we found out that they were only approved for 6 lifts by the city in which they operated. So they had 2 portable lifts inside their garage, but they weren't properly licensed or permitted. And the deal blew up over that because, you know, if you think about it, it reduced the revenues. It took a third or whatever, you know, the math is, you know, quarter of the revenues from potential revenues, because the buyer determined they couldn't operate in that space with 8 lifts. They could only use 6 until they solved the problem. Tax is another big one. We talked about, are you paying all your taxes where you're supposed to be? We talked about potentially doing a tax nexus study. So if you have a large unanticipated tax liability, it's kind of like environmental. You may not be able to resolve that issue between the buyer and the seller. The seller may not want to retain 100% of that. The buyer may not think it's their problem, and it could potentially impact your deal. And likewise, I would say litigation. So if there's any material or important litigation about your business that could affect the business going forward, that can be a problem. So those are good examples of potential deal killers. Next slide, please. So another area that sometimes people neglect or don't think about maybe as early as they should in the process, there may be, and there often are, third-party consents and approvals that would be necessary for you to even to sell your business. And you should prepare to get those in advance, not wait until the 11th hour. So for example, the owners of the business, either by law, in your organizational documents, like your charter, your bylaws, operating agreement, shareholders agreement, you may need you may need all of the owners to approve a sale. You may need a super majority, or maybe it's just a simple majority, but I would engage in that analysis early in the process. When you're looking at your ownership agreements, when you're determining your deal structure, you should also be thinking about the necessary approvals and make sure they match up. Likewise, most companies have loan and lease documents. Usually banks and finance companies have the right to approve an assignment, a change in control, anything that would materially change the business. So unless those loans and leases are going to be paid off at closing, you may be chasing the banks and finance companies to provide a consent. If the buyer wants to assume, for example, your equipment leases, maybe you've got forklifts, rolling stock, trucks, cars, whatever, that can take a long time to sort out, and it can slow down the deal process. But if you've thought about it in advance and you know exactly what you need to get, you can get to work early on it and reduce some of the time frame. Likewise, your real estate leases. Real estate leases almost always have anti-assignment or assignment prohibitions or change of control provisions that could be implicated by a sale. So you need to look at those in advance and figure out how you're going to navigate those as well. And even some customer and vendor agreements may have those provisions, anti-assignment, change in control provisions. But this is part of your reverse due diligence. If you've looked at all your material contracts in advance and you know whose approval you're going to need, you may even want to speak with those customers and vendors, earlier in the process and make sure they're going to support the business as it goes through the sale process. And let's not forget the government, regulators, the regulated industries. So if you operate in a regulated industry, maybe you're a bank holding company, healthcare, a defense contractor, you may have to file for the sale, this change of control with a regulator. They may have to approve it, and that could be an important condition to proceed to the closing. So you should work on those. And then just a quick note about the PPP loans. And I know many of our clients receive PPP loans. Many of the people on this call were the beneficiary of PPP loans, but they are a little tricky to deal with. So and I'm not going to get too granular on this, but the idea here is you either have to pay them back in full, have the loan forgiven in full, or escrowed an amount sufficient to fully pay back that loan to avoid a lengthy small business administration consent process. So hopefully many of you have already received forgiveness, or you've paid them back, or but if you haven't, the SBA is not quick to respond, and you may have to escrow funds in order to close your transaction. So with that, you can turn the slide. So I think we're at about 10:45, and we wanted to open up the Q&A. So there's a Q&A box. It should be visible on your screen. And if you want to send in any questions, I'd be happy to address those now. I'll give you a few minutes. I would also add, if you have a question that you think about later, you want to reach out to me, you can see my email address and phone number here. Please don't be shy. If anybody has questions, shoot them over. All right, I'm not seeing any questions right now. I know that Smith Amundsen educational staff are on the phone. I don't know if you've seen anything, but if not, we will sign off here in a minute or two. We will send copies of the slides in the next day or so. And I also believe, subject to any technical issues that may have been encountered, this presentation was recorded and could be viewed at a later date by you or your colleagues. So with that, I don't see any questions. So thank you for your attention this morning. We appreciate it very much. And we wish you all the best with your business and or your sale process. So I think at this point, we'll log off and end the conference. Thank you so much.